All right, I'm going to call the afternoon session to order. I promise you a really interesting and exciting afternoon. But I'll begin just between us with a confession. I always feel a little sheepish at the gaps in my knowledge of what's going on in Washington, in Congress, and at the many agencies with whom we deal, especially on the labor side, where I don't practice regularly. That ends today, and I'm going to be paying close attention to this tour in the next hour, and if you feel the way I do, I urge you to do that as well. I have previewed the slides for this panel, and I can tell you they're comprehensive and outstanding. Our guide is Roger King, a longtime friend of our center. He's worked on Capitol Hill. He had a long career representing employers at Jones Day, and he's now counsel to the HR Policy Association. Accompanying him, Matt Ginsberg is back. You met Matt this morning. You know, many of us think a law school can't claim to be distinctive until it's got, among its alums, a general counsel at the AFL-CIO. So box checked on that. Moderating all of this is my friend Ray Nardo, who is an outstanding trial lawyer with his office on Long Island, working in the Eastern and Southern districts. But he's also a mediator and a teacher at SUNY Old Westbury. So I turn the proceedings over to Ray.
Thank you very much, Mark. Appreciate it. We had some great talks today about artificial intelligence in the morning. I'm happy to tell you right now, with these two folks sitting next to me are overflowing with natural intelligence, all right? We don't need artificial intelligence here, all right? So we're going to talk about federal legislative developments and regulatory developments, and we're going to start with the legislature, and I'm going to turn it over to Roger.
Thank you, Mark. Thank you, Ray. Thank you to the NYU Law School for having me back again for your annual conference. So greetings from Washington. No reaction. So I'm not so sure that we're going to educate you about what's happening in Washington, because that assumes there are educational developments in Washington. There certainly are challenges. And what happens in Washington doesn't stay in D.C. for sure. And we really do live in a difficult political environment. So Matt and I are going to take a quick tour with you of what's happening from our perspective about labor and employment in our nation's capital. And we're going to go through the legislative area quickly. So we have a closely divided Congress, no secret, 51-49 with independents making up the 51 in the Senate. A very closely divided House, almost one of the closest divided houses in the history of our government, which makes it very difficult for either the Senate or House to move forward in any legislative endeavor, let alone labor and employment. We have the continuation of the filibuster rule, which may or may not change with the new president or the continuing president, depending on the makeup of the Senate. And as you know, just quickly, civics lessons in the filibuster process for legislation in the area of developments of law, non-nomination areas, you have to have a majority plus one, but you can't even get to that because of the filibuster rule. You have to have 60 votes. You have to vote cloture to get to an up and down vote on legislation. Now, on nominations, of course, just the opposite. And Matt and I are going to touch upon that as we go through the federal agencies. It's majority plus one with the vice president, of course, breaking ties. The only exception would be the Budget Reconciliation Act. That's a difficult process to follow. But if you can get through that process and show that there is not a new initiative being pursued, and it's really, truly a budget issue, you can get an up and down vote. Matt, any comment on the Congress?
Yeah, I just wanted to chime in on a couple very quick details. One is that, similar to the previous Senate, that having such a close breakdown makes every nomination vote very close and very hard. I was going to say hard fought, not necessarily hard fought, but there's a lot of work that goes into each. And just to illustrate, board member Gwen Wilcox, who we'll talk about, was reconfirmed last year. That was a 51-48 vote. And in fact, she got the support of the two Alaska senators, Murkowski and Sullivan, together with Sinema, but not Manchin. So there's a lot of this. It's so close, it doesn't always even break down on party lines. I'll note Nicole Berner, who is my counterpart at SEIU, was recently confirmed to position a judgeship on the Fourth Circuit Court of Appeals. That was a 50-47 vote. There were a couple absences. So these are all, they're pretty much all very, very close, some with the vice president breaking ties. The other thing I'll note is that there's a little bit, water always seeks a path, right? So there's a little bit of action in the labor and employment front around, budget bills. We recently, on the labor side, had a big effort to make sure that the FAA reauthorization bill did not increase the mandatory retirement age for airline pilots. The Airline Pilots Association is a member of our federation, and that was very hard fought, even though technically speaking it was a budget bill. It wasn't supposed to be changing statutory law.
So Matt, on the up and down close votes in the labor area, the general counsel, Jennifer Bruzzo, vice president, breaks the tie, right? Just to show you how close the votes can be in the labor and employment arena. So looking at the political outlook, and we could spend a lot of time here debating on politics, but we're not going to do that. But look at the Senate races, 34 seats up for election, 22 Ds, only 11 Rs. So all the political pundits in DC seem to be saying this is the best opportunity in many, many years for the Republicans to regain control of the Senate. I think that remains to be seen. There are many states that we have very close races. Maryland, Matt and I were talking, Larry Hogan, former governor, et cetera. So it's going to be a very interesting election season for the Senate. The House, will Republicans maintain their very slim majority? I think that's subject to question. Any predictions?
A lot of that will be decided in this state, right? This state in New York and California is likely to decide the House.
Absolutely. And then just a quick review of our leadership positions in the Senate and House Labor Committees. Senator Sanders, Chair of Senate Health, really an interesting person to have interrelationships with. I've enjoyed my time talking to Senator Sanders and his staff, albeit we have significant disagreements on labor and employment issues. But nevertheless, as you know, he has a very rich history of promoting worker rights, and he's going to continue to be in that position if the Democrats keep control of the Senate. I should mention in passing the very active participation by Senator Cassidy's ranking a minority from Louisiana. He's a medical doctor, certainly very interested in health issues, obviously, but he's taken an active interest in labor and employment matters also. On the House side, Congressman Fox is the chair, and the ranking is Bobby Scott. And I enjoy working with both of them. Matt, comments on leadership of the House and the Senate labor committees?
Just on the House, that I do think after a lot of focus on other areas within its purview, the House Education and Workforce Committee has taken more of a focus on labor issues recently. They had a hearing on several bills yesterday that one of my predecessors, Lynn Reinhardt, was the Democratic witness on, and they've been exercising their oversight muscles a little bit more with regards to the labor movement. So we've been engaged in some good correspondence with the chair.
Lynn did an excellent job yesterday. I listened to the testimony. So no legislation is going to move in the labor and employment area of significance due to the close margins in the House and Senate we've just mentioned. I do have on the screen some so-called messaging bills. The PRO Act, of course, continues to sit there. Employee Rights Act on the employer side sits there. The Protecting Older Workers Americans Act, watch this, it just came out of Senate Judiciary Committee, would restrict arbitration, mandatory arbitration on age discrimination matters. It passed with Republican votes out of the Senate Judiciary Committee. That might get some action in the Senate. I don't see it passing the House. Senator Sanders' 32-hour work week bill. I had an opportunity to testify against that bill. I think the employer community has all kinds of issues with it. It's a messaging bill at this point. It'll come back in the next Congress. The Start Applying Laboratory Transparency Act. How they come up with these titles for legislation is really interesting, to say the least. The so-called SALT Act, that would require labor organizations to file if they use salts with the Department of Labor, similar to what employers have to file if they use so-called persuaders. Any comment on that, Matt?
No, just that I do think we consider the PRO Act more than a messaging bill, so I will say that. So watch this
I understand.
space. But I do think it's also interesting. I mean, the one area where there has been some bipartisan movement in labor and employment is on cutting back on mandatory arbitration, and so it is interesting to watch this act, as well as I think you have on a later slide some that have passed.
Arbitration, as we know it today, is under attack in the United States Congress, and yes, we are going to talk about that. One last, what I would call messaging bill, at least, is the Warehouse Worker Protection Act. That was just dropped a couple weeks ago. This bill would create a new cause of action under the NLRA regarding quota systems, so-called quota systems, and so-called intervention on employee rights of warehouse workers particularly. And I don't, again, see it moving. But again, this is something to watch in the next Congress, and we shall see if we have any activity there. Matt, you just mentioned anti-arbitration statutes. I mean, I have to commend the plaintiffs' trial bar in this country, and we have some distinguished members of that plaintiffs' trial bar here in the audience. They have done a masterful job at convincing members of Congress that arbitration is generally bad for consumers and generally bad for the American workforce, more so on the former than the latter. From an employer perspective, I think that's a very dangerous policy perspective to pursue, but notwithstanding that, I think the employer community has no one to blame but itself. Overuse and misuse of non-disclosure agreements in the sexual harassment area, the potential misuse or abuse of the arbitral system in the sexual harassment area has led to some of this legislation. Matt, comments, Ray, comments on arbitration?
Yes. So we spoke yesterday, there was at this conference yesterday about the right to a jury trial. A civil jury trial being something uniquely American, it was only for criminal cases in the British system. But when you lose that in an arbitration process, that's a big deal for an employee, especially for a discrimination claim. Maybe less so for a wage and hour claim. So I think that fuels a lot of the antipathy towards arbitration from the plaintiff side.
Matt, arbitration, good, bad? I mean, what's...
No, we love arbitration in the context of collective bargaining, so all for it. But I mean, that is, the equality of bargaining power. It's not, I mean, our view is it's not the arbitration process per se, it's the inequality of bargaining power, between an individual employee who may not have many resources to really go through a full, especially a trial-like arbitration versus in a collective bargaining agreement.
And it's very effective for employers to remove the class and collective action. I think that's its main use, or one of the main advantages today. And I can't tell you how many times I will have someone in my office, I will ask about an arbitration agreement, they never signed anything, you file the case, and there's the arbitration agreement the next day at your office. So,
Well, and that's the problem. The misuse, overuse, abuse of the arbitral system has caused problems. So on the screen, you're aware, I know of the Ending Forced Arbitration, Sexual Assault, and Sexual Harassment Act passed in the last Congress. So no mandatory arbitration in this area. The question is how far does that statute reach? It's still being litigated. The Speak Out Act also passed in the last Congress, and that also restricts the ability of employers in NDAs and in non-disparagement clause areas. And again, from my perspective as an employer representative, I certainly don't favor this type of legislation. But again, the misuse and abuse by certain employers in this area is causing policy concerns. And finally, the Pump Act, non-controversial, I think a very good move on the Congress's part, and we don't see any regulatory issues there at the moment. Before I move on, any comments, gentlemen, on those areas? Well, the Pregnant Workers Fairness Act passed with bipartisan support. Labor management came together on this. We thought it was going to be non-controversial in the rulemaking process, but it was not. The EEOC, from an employer perspective, considerably expanded the reach of this new statute. So virtually any issue in the pregnancy area, even if the worker is not pregnant but has potential pre-complications or other concerns, is now covered by these regulations. The extent of time an employee can be on leave has been extended considerably by these regulations. Unfortunately, the whole abortion discussion got caught up in these regulations and delayed it. Stop me at any point. That's our legislative quick
That's our,
summary.
yeah. No,
Are
and
we good?
no, and just that is, did you mention that the EEOC regulations are being challenged in 2 lawsuits, one in Arkansas, one in Louisiana? Just during the prior session reviewed an amicus brief we're filing in support of the rules, but you can't avoid talking about abortion when you're talking about pregnancy, so that's
Right.
my
No,
2 cents.
understood. And we're going to touch on those lawsuits just in a moment. So now we're going to shift over from the legislative branch to the executive branch. This is really where the action is in D.C. in the labor and employment arena. And from my perspective, we have a renaissance of administrative law. It's never been a better time to be a labor and employment lawyer if you're really interested in substantive discussions, important court developments, whether it be the deference doctrine, Chevron, the Loper case, et cetera. This is an exciting time to be a labor lawyer, a real renaissance. And this is something that we all are going to benefit from, hopefully, in the long run. Hopefully, we will have a better outcome of our administrative law process as a result of this back and forth. This administration has done, at least from my perspective, the best job I've ever seen coordinating all elements of government in the labor and employment arena, the all-of-government approach. You have to give the Biden administration extremely high marks in that area. Matt?
Yeah, no, I think, yes, and then some, and I think part of it is it comes down from the president, who's made it a priority, and the other piece is that I think the general zeitgeist of the country right now is one where there's a real focus on economic inequality and workers organizing. It's just been in the news more, and so you're seeing agencies outside, as the prior panel discussed, outside of the traditional agencies wanting to get involved in issues, wanting to coordinate with the traditional labor agencies around issues that touch on workplace rights and workplace issues.
They have the attention of the employer community,
Yep.
that's for sure. You have on the screen in front of you at the moment the current composition of the EEOC. Chair Burrows, I know, spoke here yesterday. There's a 3-2 Democrat-Republican split on the commission, and the commission's going to remain under Democrat control through at least July of 26. So stay tuned on EEOC developments. We have a few of them listed on the screen. One very controversial potential development in a Republican administration may be the last bullet point. As you may recall, President Biden summarily removed the Republican General Counsel, Sharon Gustafson, from the EEOC in this current term of the administration. So query, will the current Democrat General Counsel be summarily removed if we have a Republican president? And perhaps more controversially, will the EEOC Democrat commissioners be summarily removed? There is no statutory protection for EEOC commissioners. Now, that would be without precedent from my perspective, highly controversial, but I can assure you it's being discussed among some of the more, how shall I state this, more active participants in the discussion of a change of administration. Harassment guidelines we've just mentioned, and Matt, you're absolutely right. There's litigation in this area. As you noted at the last bullet, we have 18 Republican state attorney generals seeking to block this guidance. I'm not sure they have standing to do that. I'm not sure what the substantive ultimate outcome may be, but that is one of many litigation challenges.
Right. I mean, it is a theme of the current administration that sub-regulatory guidance has been challenged in court, not just in the labor and employment area, but most notably the case that went up to the Supreme Court in the immigration area. So it's a little surprising sometimes to see this type of guidance being litigated.
Everything's going to be litigated today, it seems, right. So let's move on to the Department of Labor. I just want to say one more thing about the EOC. I think you're going to clearly see a lot more activity of large class action lawsuits in this area. There's just no doubt about it. This commission is going to be very favorable to that type of litigation approach. Employers need to be careful, for sure. All right, let's quickly go over to the Department of Labor. You have on the screen the current executive hierarchy of the USDOL. Notably, two very important positions are vacant. Julie Su, of course, continues to be the acting secretary. She's enjoyed I think, a relatively strong position within the administration, but a very tenuous relationship with Republican members of Congress. But nevertheless, the Department of Labor continues as it was under Marty Walsh. I really haven't seen much of any change in direction, right, or Matt?
I think that's right. I think that this Department of Labor, it has more strength within the overall cabinet than we've seen for quite a long time, and that has not decreased in any way with Acting Secretary Su, who really is sort of following through on what Marty Walsh started.
And the DOL has been extremely active, just per what Matt said. So what we have on the screen, and I apologize for the small print, but these slides are online and you can pull them up at your convenience. One of the first very important initiatives is the Department of Labor FLSA overtime rule. And if you follow this, there are substantial increases on the threshold between overtime and non-overtime exempt and non-exempt workers. And there's also a very important development in which we label as the HCEs, highly compensated employees. Pay attention to particularly that latter point. You have individuals that are going to be making a significant amount of money that are now going to be entitled to overtime. And I'm sure we're going to have differences of opinion here. This is being litigated. And I was just talking to one of my colleagues at the Littler Law Firm. A lawsuit was just filed challenging this Biden administration initiative. And again, we're going to see a lot of controversy in the reach and scope of the FLSA. Comments, Joanne?
Yeah, if I can make a point, as we remember, it used to be $455 a week under federal law for the exemption, then $684. It's going up to $1,128 per week. Similarly with the highly compensated exemption, and it's helping employees here. And I represent employees, but what I did one day is I took out my little Google machine and I went to a website about inflation. And I said, what is $500,000? That's the base amount you need for coverage under the FLSA. 1938. What would that be today? The answer is over $10 million. So the FLSA really wasn't meant to govern the corner pizza place and deli and the dry cleaner, et cetera. It was really meant for substantial corporations, but that part I don't think is ever going to be changed or indexed for inflation, which is good for employees, but just food for thought there.
So the biggest controversy under the regulations from the employer perspective is the automatic escalator clause. And the employer community is arguing, and I think here we have a high degree of potential success, that there's no statutory authority for the Department of Labor to put forth an automatic escalator clause on the change of exempt and non-exempt. But we shall see. An important worker rights statute, right?
Yeah. And just to go back one slide, you don't have to go back, but on the coordination across government, I think one of the things that often gets overlooked is the role that the Department of Labor has been playing with regards to other cabinet level agencies, which is particularly important in the last few years because of the degree of federal investment in infrastructure, in clean energy, in the CHIPS development, And in all those areas, even though those flows of money are going through other federal agencies, DOL is really playing a centralizing role because many of those statutes, the IRA also with Treasury and the tax credits, have employment adjacent requirements in the statute. So it is, I think, an underappreciated role that DOL is playing in really helping coordinate the whole of government approach.
Absolutely, they're quite involved. So speaking to the Department of Labor, and Wilma Lehman's panel started an excellent discussion on JE, on joint employer. I mean, I frankly am tired of this discussion to a certain extent, to be honest with you. We've gone back and forth at the NLRB on the JE issues. We have constant litigation in this area. Now, the board, as Chair McFerrin noted, did pass a joint employer rule, and that's being challenged. It's being successfully challenged in the federal courts. And the Congress has also gotten into the action here with a CRA, a Congressional Review Act challenge, which the Congress has a right to do. So the NLRB rule was disapproved by both the House and the Senate. The President, however, vetoed those resolutions. So we're at a stalemate in the legislative area, the executive area, but the action is in the courts. Comments?
I think part of the struggle, so there's two things. One is I think this is a legally difficult issue because of where it sits. I mean, to me, the best statement of where the law sits is Judge Millett's 2018 decision in BFI, where she really said, these are the parameters within which you, the NLRB, can act. And I think, I think if you take that decision, there's a lot that the board could do through case-by-case adjudication to decide the great run of cases. And so hopefully, I think we'll get back to that at some point. But it is, I mean, this is an area that if you had if going back to the beginning of your presentation, if you had a Congress who was in a position to pass legislation, this would be a sort of classic area of updating the law to reflect modern reality. But in the absence of that, I think the DC Circuit's 2018 decision at least provides some guideposts that the board could, in most cases, and there'll be some borderline cases, but could in most cases decide through adjudication.
Agreed. So my biggest frustration in this area is a policy matter. The strict interpretation of joint employer liability discourages inappropriately the hiring entity or the larger employer entity to make what I would think most of us would agree good initiatives in the workplace for whether it be franchisees or supplier employees in the work safety area, in the DE&I area, et cetera. Many very worthy objectives from the employer perspective would have gone forward or will go forward if we could get a more sane approach on joint employer regulations and rules. So we shall see. All right, staying with the Department of Labor, another very controversial area, independent contractor, IC. Just stop and think about it for a moment. Whether it's a local ordinance, a state law, a federal law, so much, if not everything, depends on whether that worker is defined as an independent contractor or an employee. Our whole labor and employment legislative regulatory system is based on that decision. I mean, this is a critical area of federal labor law. It's very complex, as noted in the previous panels. We have various agencies, various statutes, depending IC status differently. Very complex, very difficult area. There are 5 lawsuits pending right now challenging the U.S. DOL's independent contractor rule. This litigation is going to go on for a substantial period of time. A lot is at stake. I understand the employee perspective, but Matt, you should comment on it.
Well, just to echo Jonathan Harris's comments earlier, a lot of the action here is at the state level because of the, we'll call it gridlock or legal disputes at the federal level. States are not waiting around because of, given the structure of the FLSA and a lot of other non-NLRA employment-related laws, states do have power to take action. So in Massachusetts, as it was referenced, we have affiliates who are pushing different positions, but there's certainly a lot of play at the joints at the state level. But it's complicated. Try explaining this to your non-lawyer friends about how in one state You have both federal and state law that applies, and even state law will, in both federal and state law apply different employment tests for different statutes, workers' comp, UI, FLSA, the IRS, and federal tax law. So it's again, something that cries out, but I do think, unlike a lot of these other areas, the states are not waiting around to move on this.
And that's one of the sad points, I think, of our entire regulatory and legislative system in this country. Federal labor law has been the backbone of how we regulate the workplace, but it's changing. And the companies we represent at HR Policy are most of the Fortune 400 companies, and they every day are complaining about this patchwork of federal and state laws. But even within states like California, you have different jurisdictions having different standards in the leave area, family leave area. This country was built on a federal labor law system, and we can debate back and forth the wisdom of some of these state initiatives. But we're starting to see red states push back from blue states. Tennessee, Georgia, Alabama have passed statutes that would essentially prohibit certain labor-friendly initiatives. And then we have blue states going in the opposite direction. Preemption is a word that's difficult for people in Washington to accept, but I submit to you, long-term policy-wise, we really need to do a better job. I mean, the Title VII was not enacted by the City Council of Pasadena, California. It was enacted by the United States Congress. And if we're going to have sane labor laws in this country, they need to be federal in nature to the extent possible.
Roger, as a short-term measure, would there be support in the management community for an agreement that if you are put aside Uber and Lyft and whether they're sort of in a state of their own, but if you are doing the same work as your regular employees, that is presumptively a misclassification. Now, so I'm not talking about people doing different work, but doing the same work as your regular employees.
Same work, but in a different way, off of a platform. I mean,
No, I'm not talking about the platform workers. I understand that.
There are all kinds of
I mean, this
legitimate
is,
disputes here.
it just
that need
seems
to
to
be-
me an abuse. That is a particular abuse that maybe there could be bipartisan support for. Give some thought to that.
I'm all for bipartisan support, for
In the right
sure.
places, I understand that.
So,
But what's the legitimate reason, you see, for allowing that sort of a classification when they're doing the same work as your regular employees?
well, Sam, we don't have time to get into
I know.
this that deeply. We need another category. We need an independent worker category in this country that takes the attributes of both employee and independent contractor and melds them together in the same way. At least that's my perspective. But let's keep going through the regulatory environment here. The OSHA walk-around rule, you may not have paid a lot of attention to this. This is now a rule out of USDOL, effective May 31, 2024. This permits third parties to have rights to go on inspections of worker-oriented safety concerns. It permits, at least from an employer perspective, too wide of an open window for virtually any third party, including many of your affiliates representatives, Matt, to come into a unorganized workplace and perhaps cause havoc. I understand the other part of the discussion, and I should turn it back to you. That
Well, yeah,
is-
so I mean, it has been existing law that our affiliates where we have bargaining status have a right. And so here you have an extension. And I think part of this is that a lot of the workplaces where OSHA is doing inspections that are unorganized are low-wage industries, many times with a lot of immigrant workers. And it's not just unions, but it's community-based organizations and others who oftentimes will serve the role as a translator, will serve the role, which was one of the examples given in the reg as a go-between to help communicate between the government, the employer, and the employees in the workplace. I will note that, not shockingly, in the last 48 hours, this case has been, this regulation has been challenged as well in the Western District of Texas. Yeah,
Are we back in Texas again?
we're in Waco. In this case, we're
Thank
in
God for
Waco.
the Eastern District and Western District of Texas, I guess, from an employer perspective. I was about to mention that. The U.S.
Yeah.
Chamber of Commerce has initiated litigation challenging this rule. So if you stop and counted all the legislative moves, executive action moves, and counter moves in the courts, you'd be in double digits. It is one of the most active environments I've ever seen in administrative law, for sure. All right, there you have it, the walk-around rule, some pluses and minuses. I agree with you, Matt. In certain industries, certain employers, this is going to be helpful. The question we have from the employer side, is it going to be misused and overused, or is it going to open up too wide of a door for third parties to come into an employer's workplace? So we shall see. All right, let's go to the FTC. It was mentioned earlier by one of the panelists. We are now looking at different agencies that most of us in this room, as labor and employment lawyers, didn't follow that closely. I know I didn't. But now in my portfolio, in addition to the NLRB, EOC, DOL, I'm following FTC, US DOL, SEC, and a host of other agencies because of the all-of-government approach. And it's literally anything and everything coming out of this administration that has any kind of nexus with labor and employment issues. FTC is a perfect example. We've already had some comment on this from a prior panel. I don't want to be repetitive here. The rule, at least effective date at present, is 2024, September 4. It's being challenged in 2 lawsuits, again in Texas. Here, I think there is a very legitimate point from the employer community. The FTC has no jurisdiction in this area. They have no experience in labor and employment. This is a major questions doctrine issue. This is a problem because of the precedent it would create in the employer's eyes, at least with respect to FTC, labor and employment, and other types of intervention in the workplace. Matt?
The FTC obviously took a very aggressive position here, but I think the underlying point is that this issue is on the state level. You can see is just sweeping the country. I mean, there's definitely a sense that I think is pretty broadly held that there's been a real overreach in this area, and this is the pendulum swinging back in the other direction.
It's another example of the employer community, unfortunately, overreaching. I mean, Jimmy John's workers and no compete agreements, no one in this room would defend that. At least I can't imagine anyone making that kind of argument in the same thoughtful way. But that's what's led, in part, to this policy discussion and this rule from the FTC. I'm not going to read, we're not going to read for you what's on the screen, but you can follow the slides at your leisure. I think we have a pretty good outline of what this rule is about. Existing agreements are exempt. New agreements are prohibited as a general rule very broadly. There's all kinds of issues from a compensation perspective. Holdback agreements, forfeiture agreements, should they be a part of this new rule? I think not, but others may disagree with that. Preemption issues, excuse me. And Matt, you're absolutely right. This is an area where the blue states are going to be very active, and the red states, we're not sure.
Although I think there is some history in red and purple states as well of regulation. Yeah.
How do we think this would affect non-solicits?
Well, the FTC is left that alone to a certain extent, right? I mean, no rating clauses, as I read the rule, are still going to be okay if you draft them carefully enough. Now, again, if you go too far, and the no rating clause also impacts your ability to work for a competitor, then you're going to run afoul of the rule. So this is going to be a very active litigation area. The solution, at least from my perspective and our association's perspective, is some federal legislation here. That would be helpful. We shall see. The whole competition area and labor issue of FTC, we've touched upon that. This is something really you should watch. DOJ filed an amicus brief in the Atlanta Opera independent contractor case. Department of Justice filing with the NLRB, unprecedented from my perspective, but it was from a competition perspective. FTC opposing the Kroger-Albertsons merger, primarily because of USCW opposition, right? The Nippon Steel acquisition of U.S. Steel, DOJ is looking at that. So this whole competition area and federal and state labor law, that's certainly in play, right?
Yeah, absolutely. And I mean, I think part and parcel of sort of more of a sense of a national industrial policy. So, taking a look at these issues from sort of the broader, industrial development lens.
I don't know what's going on. National Labor Relations Board, I found Chair McFerrin's comment about her concerns about the relationship between the board and the courts of interest. As an active participant in the federal courts on behalf of employers, I guess I would have responded had I been on a panel with her. Chair McFerrin, you're going to see a lot more. You're going to see a lot more employer pushback on the entire scope of representation issues being pushed in the Congress, and you're going to see a lot more pushback in the courts. This board has pushed the envelope, at least from the employer perspective, Cemex included, to the maximum. And you're going to see then the employer community look for options to try to stop this, what many of us would say is overreach. And I can tell you, and having filed a couple briefs and argued a case recently in the circuit court and filing a number of amicus briefs, that you're going to see more and more challenges to the board as a whole because of its constant flip-flopping, and from many of our perspectives, its lack of a thoughtful, neutral, adjudicatory approach. And the whole deference issue to the board is going to be in play for some period of time. And if the general counsel continues to expand the scope of the act from her perspective, which I certainly respect her right to do, she will see more pushback. But Matt, and that sort of leads us into the constitutionality question also.
Yeah, no, I mean, there's no doubt that the overall framework in which administrative agencies, the board included, operate is going to be under a great deal of, there's going to be a lot of turbulence in the next few years. I think there's no doubt, and the board will experience that like the rest. I mean, the thing that's interesting to me is that, to me, the most striking thing in labor relations in the last couple of years has not, and I mean this with no disrespect to the board, has not been the board's decisions, which although there have been some that have been quite groundbreaking, it's been just literally what's happened out in the field in terms of, you look at a place like Volkswagen, you look at the big three bargaining, you look at the UPS negotiations. It's a combination of coming out of COVID, a low unemployment economy, a real focus on more of a central industrial policy. So what's interesting to me is you could have both things at the same time. You could have the board's doctrinal underpinnings under real attack in the courts at the same time that there's a lot of activity in the field, in the streets. And so where that lands, to me, raises a really interesting question, because it may be an opportunity to touch that third rail, make some changes in the statute, which has been around for so long. If there's sort of a meeting of the minds that both sides decide that maybe there's something they want to change.
Agreed, totally agreed on that. So you have in front of you the pictorial composition of the board at present. The key issue here is Chair McFerrin's term ends in December of this year. And of course, the outcome of the Senate elections and the presidential election will have a great bearing on whether she is reconfirmed. I'm assuming she's going to be renominated. I think that's probably a given inside the Beltway. So if she is reconfirmed, it means that there will be a Democrat majority on the board at least a year and a half into the Republican administration. And this is going to be a firefight in the Senate.
That assumes a Republican. You're assuming a Republican administration.
I'm not assuming anything. But I guess I did assume that in the way I stated the question.
Yes.
No, I am. Matt knows my politics pretty well. I'm not yet on that bandwagon on the Republican side, but I'm certainly not on the Democrat bandwagon either. It's a difficult time in our nation's capital, Matt. So follow the composition of the board closely. We have that vacant Republican seat that's been vacant for over a year, which I think is quite unfortunate and quite unfair, frankly, to the Republican member, Marvin Kaplan. He has 12 attorneys in his staff to 40-some for the Democrat majority members. So we're not going to spend a lot of time on the NLRB. We've had previous panels on this. I just would note that there's still one case pending in the United States Supreme Court on whether a former NLRB General Counsel Peter Robb was lawfully terminated. That case is on hold until the Court looks at some other cases that are pending and renders decision. So that issue is technically still alive. SpaceX, we've talked about.
Can I just say that,
Yes.
you know, if your Freudian slip prediction comes true, we might change our positions on the outcome of that case.
Well, you think so?
It's good to see flexibility.
You think he would argue that general counsel cannot be removed? Well, you know, while we're on that subject, I did skip over this, I didn't mean to. So there's a question being raised in some circles in Washington whether a Republican president could summarily remove existing NLRB members. And while there is statutory protection, as noted in our slide, for NLRB members, there's an argument under Humphrey's executor that as this board becomes more of a executive agency, a policymaking agency, we heard about THRI and damages through Chair McFerrin's comments. The issues come into play whether these are executive agency policy people, and under the unitary government, unitary executive doctrine, the president should have some summary removal powers. And former Chair LRB member Wilma Liebman is smiling at me. Can you imagine, Wilma, the chaos if a new president summarily removes existing NLRB members of the opposite political party? Matt, you talk about chaos. But I can assure you this is being discussed among certain people in D.C. today. SpaceX constitutional challenges, right to jury trial. And again, the argument starts to develop as THRI Inc. expands, as more damages are available under the Act. Do employers have a right to a jury trial? ALJs, are they in fact lawful? Sam's going to cover that, I know, in his constitutional Supreme Court discussion. So this two-layer removed argument, I think it has some appeal. And I just mentioned the removal of perhaps EEOC commissioners and LRB members. We shall see. It's a chaotic environment, but not to be surprising to many of us. Matt? Right?
Yeah, I made a couple comments about this earlier. I do think the other piece that's to watch out for in coming Supreme Court terms is the Fifth Circuit, who's most of the judges I would not agree with on most issues. They've gone so far out there that they've become the favorite target of the Supreme Court over the Ninth Circuit recently. Wow. And I think we may see some more of that. There's some very interesting district court judge decisions from Texas, some of the same judges appointed by the former President Trump, who are complaining about the Fifth Circuit's actions because they've gone so far out there. And so, I mean, that's partially my personal view in terms of how far out there they've gone, but it's also a concern for the federal government, the Justice Department, because so many federal agency decisions are getting caught and held in the Fifth Circuit, even when it's not clear they're appropriately there. So I think this is sort of an evolving administrative law issue to keep an eye on.
You know, I've had those similar feelings about the Ninth Circuit on the other side of the discussion. So NLRB issues to watch. We don't have time to get into these in any detail. They're on the screen. We've touched upon a number of them. This so-called captive audience speech issue, that's yet to be ruled on by the board. Stay tuned there. Some First Amendment and free speech issues certainly come into play there. Card check recognition, we've heard about CEMEX and the Joyce-Sullivan doctrine. This general counsel is going to continue to push the envelope. I don't think there's any question about that. Here's one issue I think I really would want you to watch. And that is in an 8A5 case where the employer has alleged not to bargain in good faith, and the board decides that 8A5 remedy is an appropriate remedy, but how far? This general counsel suggested that she would have the authority to put the parties in a position they would have been had the employer bargained in good faith, which would mean retroactive pay, retroactive benefits, huge money on the line. Now, we shall see if the board is presented with that kind of question clearly and makes a decision on it. But Matt, in my opinion, that's interest arbitration through the NLRB, and I would submit very dangerous from an employer perspective.
I can certainly understand it. And from the union perspective, that Excello remedy idea is one that is begging to be answered. I think they've got a ton of cases ready to go. And I think the question that everybody struggles with is, what is the measure of damages? I mean, that is that's, I suppose, the flip side of your interest arbitration.
Right.
So it'll be, I mean, it's been briefed, they've got it there, they've got to make some decisions about whether they want to go there, and if so, how they're going to measure damages.
It's going to make collective bargaining more interesting and challenging. So
Can I add one issue?
Oh, of course you
Yeah,
can, absolutely.
one that I think is really developing, I mean, it's obviously been out there, but I think we're going to see a lot more in the next year, considering all the events on the ground we've seen, is this issue of the line, when you have mixed political and workplace speech, how that gets dealt with. I mean, we had the recent Home Depot decision, which is now up, I think, in the Eighth Circuit. Which is one version of that from the Black Lives Matter movement, but now particularly with the student worker protest on university campuses. You know, we had the strikes out at UC Santa Cruz, which is not NLRA covered, but those types of activities are going to continue to raise these issues. So I do think we're going to see a lot more action in this area.
on that point, Allison has just added to the conference materials the brief in the Eighth Circuit. It was just filed today by the employer, the opening brief. It's a very challenging philosophical and policy question, put aside the facts of the case. How far can employees go in acting out in the workplace to display political messages? In this case, as you may recall, a Home Depot worker displayed on his apron that we all see in the orange Home Depot uniform scenarios, the BLM message. This is a Minneapolis store that was very close to where the George Floyd killing occurred. And the political environment at that time, obviously very charged. The employer argues that this was a pure political message by this employee that had no nexus whatsoever to terms and conditions of employment. There had not been any prior rallies in the store or employee activism on this issue. The board came to a different conclusion. The board found that this was protected concerted activity, and there was a nexus, the board found, between racial issues in the workplace at that store and the wearing of this message. But where do you stop? I mean, we're filing an amicus brief. I'm working on it right now. From an employer perspective, a retail-facing employer perspective, customer-facing perspective, where do you draw the line, Matt?
Right.
You're putting the employer in almost an impossible position of trying to police political and social issues in the workplace.
Right. Well, I don't know. I'm not sure I'm prepared to say where you draw the line, but I do think that this is this obviously a recurring issue. We saw it. I mean, the ILA case.
Right.
You have the Day Without Immigrants advice memos from about a decade or so ago. But there's something, and I sort of a theme that runs throughout a lot of the panels in this conference. There's something changing about the nature of the workplace and the expectations that employees, particularly younger employees, I think, bring into the workplace, that there isn't such a clear differentiation between what happens at work and what happens, in the outside world. If maybe all your work is teleworking, and so you're flipping between your personal email or personal social media channel and the work you're doing for the employer. And so where do these lines cross? So I just think this is a rich area where we're going to have a lot more fact patterns coming up.
As we get closer to this very controversial November election, I know the employer communities that we represent, we're really concerned about how do we regulate the workplace, not run afoul of federal and state statutes. Mark, I know we're about out of time here. We're going to finish our DC tour here closely. We've already talked about Dartmouth College. Their men's basketball team finished last in the Ivy Leagues. I was talking to David about this. So this is their way of at least making a statement, I guess. Additional everybody issues, EEOC, all kinds of initiatives there. Just briefly, in the U.S. Supreme Court, and I don't want to intrude on Sam's jurisdiction here, but you look at this court, look at the age of the justices, look at the important issues they have before them. They have become a critical part of the decision-making process that many of our employers and unions engage in, even more so than in the past. The impact of what happens with Chevron, the pending Loper case, and a Relentless case. I mean, huge complications and issues for the workplace. The SEC case that Sam's going to cover, the Starbucks 10J case that we've heard about earlier. There's a case, it's not in your materials, I didn't include it. It has to do with the statute of limitations with the Administrative Procedure Act, which is a 6-year statute of limitations. The court has before it whether an employer or a trade association that is harmed by an administrative rule but yet didn't challenge it when that 6-year statute expired can still challenge the rule because it was not adversely affected during that 6-year period. Can you imagine if we open up the APA for challenges beyond 6 years? Very important. Finally, the composition of federal courts, as Matt has touched upon, both the prior administration and this administration have certainly seized on the importance of who's sitting in that judicial seat. And stay tuned there. The composition of the federal courts at all levels is in play.
Just the two very quick comments on that. On the Supreme Court, you know, one of the advantages, so to speak, of a 6-3 Republican-appointed majority is there are no illusions on the labor bar side that we want anything going to the Supreme Court. And that in combination with everything else we've talked about in terms of what's going on in the whole of government approach, low unemployment, I think has really pushed a lot more unions to engage with employers directly, try to work things out. You know, you need skilled workers. We have training programs for skilled workers. We just need to have a cooperative, you know, positive relationship rather than try to litigate your way to things, because ultimately the courts are not generally friendly jurisdictions. On the courts of appeals, President Biden confirmed his 200th judge yesterday or today, which is they're on track to meet the prior administration. I think you're totally right with a 50-50 Senate. This is one of the few things that they can do that really changes the overall complexion of the government. We've been very pleased that President Biden has continued President Obama's push towards diversity in the judiciary, but has included judiciary at practice areas as well. I mentioned Nicole Berner. We've had a number of labor lawyers from either side. We all know are practical, good people who would make great judges. So we're glad that he's on the union side has appreciated that fact. But also public defenders, other folks who haven't been traditionally sort of the folks looked to for the federal judiciary. So we've been very pleased with that.
So Ray and Mark, that's a very quick tour of D.C.
Yeah, if I could just make one point. As we know, there are 9 justices on the Supreme Court. Right now, there are no vacancies. And since there are no vacancies, we know that Professor S. Stryker will remain here at NYU Law.
Well, thank you.
Before I let you go, can I ask Roger, and to a lesser extent Matt, one question?
Thank you.
You've alluded to Trumpism being different than traditional Republicanism. Roger, does the employer community imagine that a Republican administration, at least with regard to our issues, would be consistent with a Romney administration, a Bush administration, which is to say generally a lighter regulatory touch? Or is there uncertainty about what the second term might look like if Trump were to win?
There's uncertainty on every issue as it relates to our former president, from my perspective. And, you know, we haven't had time to get into what I call the leaning blue Republicans, per your question. Mark, look at Senator Hawley from Missouri, Senator Vance from Ohio, Senator Rubio to a certain extent in Florida. So you have some push toward the employees union side by certain Republican senators. But as far as the next administration, you're going to see utter potential chaos, as we've noted on the EEOC and LRB. I think you're going to see summarily changed removal type situations. And frankly, predicting any thoughtful philosophy on labor or any other issue with the presumptive Republican nominee, I have totally given up hope. I'm a John Kasich Republican, but we don't exist anymore, I guess. So it's going to mean, I would close with this, it's going to mean a lot more work for everybody in this room, irrespective of how this presidential election and senatorial election it turns out. And hopefully, Matt, we can work together and stay out of the politics, right?
Good luck to,
Thank you.
definitely to working together.
Thank you.